Okay, so turning to the first question we were going to talk about today, and that is returning people from furlough and bringing furlough to an end. So how do you bring furlough to an end? Initially, it's probably worth noting the good news that we had yesterday on the extension to furlough arrangements. So you'll have probably seen the Chancellor's announcement. It's now going to be the case that the current arrangements will continue as they are until the end of July. We'll have a sort of an evolved version of furlough which will run through August, September, and October. The revised scheme that has some changes. There's going to be a reduced government contribution in the revised scheme, and the employer will have to make up the difference to the capped levels, which stay the same. And there's also going to be the possibility of part-time working for your people during furlough. So there's going to be more on that in the next couple of weeks, we're told, which is something to look out for, but obviously a good breathing space for a lot of businesses at the moment. Even so, I think a number of employers are bringing or planning to bring furlough for some of their people to an end early, and so early before the scheme would otherwise end in itself. And that'll be because of their business is returning and they need resource, they need people to work on that. And really, ending is a pretty straightforward thing to do, and really achieved by serving notice to the employees in accordance with the written terms that they were put onto furlough with. So if there was something in the original furlough letters which confirms notice periods to bring furlough to an end, it would be that. Or if it wasn't covered off in your communications, then really it would be whatever is a reasonable period. So I'd have thought 3-4 days would be a fair amount of time. And obviously paying conditions return back to normal levels once furlough has ended and the individual is back at work. Now, it's worth remembering that, well, certainly until the end of July and possibly longer, depending on what the rules of this evolved furlough scheme will be, but certainly to the end of July, the 3-week minimum period for furlough is still in place. So if you have anybody put onto furlough late in the day, where you've got people rotating on and off furlough, you obviously don't want to end furlough in the middle of a period so that you haven't achieved your 3-week block or your minimum 3-week block. So just keep that in mind. Okay, so that was our first question. Moving on to our second question, and this is it. If you're not bringing all of your people back to the workplace, if you're bringing some people back to the workplace, but you're not bringing everybody, and that's whether they're coming back to the workplace from home working or whether they're coming back to the workplace from furlough. If you're only bringing some people, how do you decide who to bring back in that situation? And I'll hand over to Adam, who's going to give an answer to that question.
Okay, thanks, Tim, and good afternoon, everybody. Yeah, well, as Tim said, this question is going to be relevant whether you're bringing people back from furlough arrangements or you're bringing people back who've been working from home for a period. And also with the social distancing measures that you're going to have in place, which we'll come on to talk about in a moment, most businesses will have real difficulty with operating at full capacity. So there are going to need to be some decisions made about who you bring back and when you bring them back, so some sort of selection exercise. Well, I guess as a starting point, you as an employer will have a wide measure of discretion as to who you bring back to the workplace and how you decide who to bring back. And you'll be able to base your decisions then on the operational needs of the business. So which roles need to be done on site, and where you've got a number of employees doing the same or similar roles, I guess your decision will come down to things like the particular skills and experience of those individuals. But there's a real potential here for discrimination issues to arise. So whilst this will be primarily led by the business and is an operational decision, there's a key role for HR in ensuring those decisions are calibrated and you sort of navigate the discrimination risk. Now, discrimination could arise in a number of different ways. So, for example, take a manager who decides to bring back his colleagues who he gets along most with, and they all happen to be male. Well, a female member of that same team might say, well, that's unfair, and in fact, it amounts to sex discrimination, and she might have a very good argument. So there's a key role for HR in challenging managers' decisions and their thinking and ensuring they're being objective as possible in who they decide to bring back. But discrimination could arise in various other ways, so indirect discrimination issues. Clearly, lots of employers will have ongoing childcare responsibilities in the current climate. So if you decide not to make any allowance for that or any accommodation for people with childcare responsibilities, there's a clear indirect sex discrimination risk. We know from case law that the courts will recognise that female employees are much more likely to have childcare responsibilities, so they're going to be disproportionately impacted by that sort of practice. But equally, on the other hand, if you decide to say, well, let's just leave everyone with primary childcare responsibility at home and bring everybody else in, there's a risk there that you're going to be indirectly discriminating against your male employees or potentially younger employees who don't have children or who don't have childcare responsibilities. So there are lots of angles to this, but I guess the good news on indirect discrimination is it's possible to objectively justify it. And so considerations like, well, what is your rationale for choosing particular employees over others? How extensively have you consulted with staff and taken into account preferences will be really important. But the big thing to avoid with discrimination, and particularly indirect discrimination, is having a blanket policy. So to the extent that you can take into account personal circumstances, that will be very helpful. Well, a couple of other ways that discrimination could arise here. Clearly, there's the potential for disability discrimination. So you might have employees who have underlying conditions which amount to a disability. And for those employees, you've got a duty to make reasonable adjustments. And in this context, your duty might extend to not requiring them to come into the workplace, at least in the initial phases of reopening. Now, for employees who are on the extremely vulnerable list, the clinically vulnerable people, that's relatively straightforward because they're going to have to stay at home, they're going to have to shield, and they can be placed on furlough, kept on furlough, and even when furlough comes to an end, they can be put on sick leave and they're entitled to statutory sick pay. But there'll be other employees with other underlying health conditions who you need to think about here too. Another potential angle, I guess, is religious discrimination. So if you're asking people to come back and wear personal protective equipment, that might be difficult for some individuals of particular faiths, people with beards or turbans who can't wear face masks or face coverings for religious reasons. So that's something else to bear in mind as well. Again, discrimination that's indirect of this nature can be objectively justified, but you'll need to give it some thought in your selection exercise. I guess the overarching point here is to base your selection on objective criteria as much as possible and avoid blanket policies. But it also makes sense to consult with your staff, and that's to try and get people on board with your approach, but also to flush out issues at an early stage so you can deal with them. And just before I hand back to Tim for our next question, a couple of other points to consider here. So you might want to think about asking for volunteers, people who are volunteering, they're happy to come back to the workplace. That will reduce your pool for your selection exercise. Or as many employers are doing, you might think about having separate teams that you rotate, and that's treating everyone a bit more fairly, a bit more equally. But as with all of these things, communication is going to be critical. So the earlier you can engage with your workforce on these issues, the better.
Thanks, Adam. Okay, so moving on to our third question, and this is quite an interesting one. What if somebody refuses to come back to work? So that would be somebody refusing to come back into the office after a period of home working is coming to an end, or whether they're refusing to come back into the office in a situation where furlough has come to an end. And perhaps linking to what Adam says, it may be where all of your people are coming back, or actually you've selected this person to come back. Well, on the face of it, this becomes a disciplinary issue. You've given a direct lawful instruction to your employee. They're employed under their contract to work for you, and a refusal to come back to the workplace could be regarded as unauthorized absence, and so could be a period of unpaid leave, or it would be a disciplinary matter, possibly even leading to dismissal, depending on the approach you were taking. Now, I say on the face of it, now there are obviously some difficult employee relations issues about that, but there's also another potential legal issue here, and you may have seen this being mentioned in the press in the last few days. Now, the employment law that applies here says that if there are circumstances of danger, so it refers to the term danger, if there are circumstances of danger which the employee reasonably believes to be serious and imminent, then the individual can refuse to return to work. And this also extends to a situation where he or she is refusing to protect himself, but also to protect others. So in theory, protecting people who may live in the same household as the employee. And the key thing is that if this situation applies, if there is this reasonable belief and the employer dismisses the employee, then it becomes an automatically unfair dismissal. And similarly, if this situation applies and instead of dismissing, you subject them to a detriment, so you don't pay them, for example, then there becomes a claim for that amount of money. And it's a day one right. There's no service requirement like there normally is for unfair dismissal. So in theory, anybody can argue it. And it's also uncapped damages. It's one of those limited scenarios where the cap comes off the unfair dismissal claim. And the relevant law, if it's referred to you, Employment Rights Act, and it's section 44 and section 100, and it's not really a much visited section before COVID came about. So it's got obvious application if you're in an environment where you're handling dangerous chemicals and you're worried about how they're being stored, for example. But clearly it's much broader in scope than that, and it covers an individual's workplace, and it may even cover a perception of danger in relation to a journey to work. So the question of public transport, which is obviously a very key issue for us all at the moment. So it's out there as a topic, and I saw on the front page of the Times this morning there was a reference to the unions talking about this. This was teachers striking, or teachers potentially not returning to schools, and it said that unions were advising that employees don't have to work if they believe conditions are unsafe, and they have, quotes, tooled up members on how the law works. So it's something which is out there and maybe posed to you as an issue. Now, what do you do in response? Well, it's probably likely that COVID would be regarded as a serious and imminent danger. You know, all of the government guidance we've been seeing talks about it in that way. So the key question then is whether the employee's belief that the danger is serious and imminent when they come back into the workplace, is that a reasonable belief for the employee to hold? And I imagine a lot of employers will want to push back on this on the basis that it's not a reasonable belief. If the employer is following government guidance, so the guidance that was issued on Monday evening about creating safe working environments, it feels right to say that the employee shouldn't reasonably have that belief. But it's obviously not clear cut, especially when it comes down to how each employer is implementing the guidance in their workplace. Each workplace is different, and it's also not the sort of thing you want to be having an argument about from an employee relations issue, or in theory fighting over in a tribunal in the coming months. So no answers yet, I'm afraid. I think it's more that it's going to be a fact-specific analysis of your work environment, what you're doing, and understanding your employees' concerns. But it's important to be aware of this issue because it's starting to get a lot of airtime, certainly amongst unionized environments. It may well be that non-unionized employees start to talk about this particular right as well. There's a similar thought around whistleblowing. So where people raise concerns, raise protected disclosures, and then they're treated badly or dismissed because of raising the concern. It's not impossible that someone might say raising concerns about the safe working environment could be whistleblowing, but I think it would be much harder for them to suggest that they were then dismissed or the reason they were not paid was because they raised that concern. It's more likely to be a problem of causation for them. But going back to this reasonable belief idea, that's the one that I think is going to be most challenging for employers. Now, aside from people who have general concerns like that, you may well have other people in your workforce who don't want to come back for specific personal reasons, and you'll want to think very carefully about what you do with these groups. And I imagine if you've got the ability and the capacity, you will be accommodating for them. So I'm thinking, for example, around people who are either clinically extremely vulnerable or clinically vulnerable people. Now, going back to this section 44, section 100 claim point, they're probably in a place where it's much more reason for them to have a belief that there's a serious and imminent danger, alongside what you would regard as more traditional disability discrimination issues, as well as maybe people who have disabilities in your workforce who aren't either clinically extremely vulnerable or vulnerable. I would expect it would be very difficult to get these people back to work in a situation where they didn't want to return, and certainly the extension of the furlough arrangement is very good news in relation to that group as an alternative, or if you're home working, allowing continued home working. And I think it's a similar sort of answer. You have people who wouldn't want to come back in because they're shielding in relation to people at home who are clinically extremely vulnerable or vulnerable people as well. So I think it will be challenging for the same reasons to try and insist on them coming back. Another group of people who you may have in your workforce, pregnant workers, so expectant mothers. The law already provides protections to pregnant mothers around their health and safety and that of their baby, and if there isn't a safe working environment, they have the right to be suspended on full pay. Again, it's not entirely clear from the government's guidance really whether they regard pregnant women as being in a group who need to be suspended on full pay immediately. I suspect it comes down to the role that the individual is performing, the procedures you're putting in place, and having a risk assessment in relation to them and what they do, as to whether they should be either returning to work or whether they would more safely be suspended on full pay if they can't homework. And then another group of people who may well have trouble in your workplace are people with childcare issues. Now, in a situation where the schools are not going back, or certainly not all years are going back, you can very well imagine an employee responding to you, requesting a return to work, saying, well, I simply can't because I've got childcare responsibilities and I can't leave the child at home and it's not possible for me to return. Now, The furlough arrangements, again, because they're continuing, gives you an avenue to deal with that, if that's going to be a suitable compromise. If you didn't furlough, then in theory, they're not necessarily a protected group like the people who are worried about their own personal safety, their own personal health. There may be a sex discrimination angle if women can show they're more statistically more likely than men to be child care people with responsibilities for childcare, but that would be quite difficult. And you may well end up talking about a termination in that sort of situation, but that would be a hard outcome. I think, again, like as Adam said, the discussions with employees around who returns to work out of a certain group of people, I think a lot of it comes down to having communications with your employees at an early stage, trying to understand their personal circumstances, trying to understand whether they have concerns and what those concerns are, and discussing with them what the business is doing to create a safe environment for their return, and then dealing with issues that then come back from that. Final thought from me on that, and it's a sort of a consistency point. I know a lot of clients have felt quite challenged by this generally in terms of allowing people to stay off home working or allowing people to furlough when there aren't obvious health concerns for them. If you've got groups of people who perhaps reluctantly or with some reservations are coming back to work, then you've got another group who push back and you let them stay off. It's not a particularly nice message that you're sending out to your workforce, and I think a lot of people will be looking to have some consistency, but with that consistency comes the challenges which I've touched on. The question of the reasonable belief, you remember, talks about whether there was a reasonable belief of serious and imminent danger. And I think, as I said, a lot of that will be to do with what the employer has done in the workplace to create a safe working environment, which sort of brings us on to the health and safety side of this, and the health and safety obligations, including the sort of messaging that's come out of government over the last few days. And I think at that point, I'll bring Doug into things and into our next question, really, which is looking at what the health and safety obligations you have as an employer in the context of your people coming back to work. So, Doug, can I pass that one to you?
Yes. Good afternoon, everyone, and thank you, Tim, for the intro. In this last session, I think we'll try and round out that point that Tim's kind of already raised around this imminent danger and the kind of employment law issues that's going to cause, and the slightly separate issue, which is very closely linked but separate, of your health and safety obligations as an employer. I mean, looking at those kind of the likely routes to a civil or criminal liability for a safety incident is quite interesting here. It's a very important consideration, but I think it will probably end up being more a discussion on how you kind of mitigate the Section 44 and Section 100 concerns rather than a realistic danger for most businesses. Just by way of quick recap, under health and safety law in the UK, I'm sure you're all aware, you have a statutory duty under the Health and Safety at Work Act and a plethora of subordinate regulations to ensure that your workplace is safe for your workers, employees, but also any other visitors to that workplace. So that's a fundamental obligation. It's always been there. It's interesting because it's a strict liability, or it's an inverse burden of proof. So it is quite a challenging duty to kind of discharge. If something goes wrong, there isn't really arguments of causation. It's you have to demonstrate that you took all reasonable steps to ensure there wasn't an issue. And so in this case, where you have what is a communicable disease, which isn't solely related to the workplace, it would be very much following what the government guidance is. So I think the chances of most businesses getting a regulatory action against you are going to be remote, as long as you follow the latest government guidance, you implement it. Crucially, you've got to tailor it to your given working environment. document all of that, make sure it's communicated and applied with, and then given how fast moving all this is, it's updated on a regular basis. So for some businesses, that will need quite a thorough risk assessment and documentation process to be gone through. I mean, getting people on board, and also I think to kind of manage the risks, the employment law risks, it has been said in the guidance which was released on Monday, and that's quite sector specific as well. So you need to look at your correct guidance. There was some very clear messaging that this needs to be a consultation undertaken with your employees and trade union reps as well. So the guidance really needs to be approved, and there's multi-stakeholders, which I think will assist in that any argument of reasonable and serious imminent danger. So that's the bare minimum you have to do to discharge the duty. Sitting with that, there is always the risk of civil liabilities arising. That is going to be more difficult to manage, much like the employment claims we were talking about. But again, here it will be very challenging for that to be successfully brought, given again this is a communicable disease. So how can someone accurately show that it was picked up in the workplace will be challenging. I think obviously there's a spectrum from an office, let's say like Travers Smith, through to a care home situation where it might be easier to prove that was where the infection was picked up. So really the key is kind of following that guidance, as we were talking about earlier. That will help manage both these liabilities. I mean, I think I've got to be clear that we do expect the health and safety executive to be reasonable in the implementation of this, but it was clearly stated by Boris Johnson the other day that the HSE will have investigation powers and will be expected to investigate. They've had an assignment of 14 million extra pounds to help them in that, which is quite eye-catching. And we are aware of a number of our clients who have been continuing to work throughout the crisis, who have started to receive notices suggesting that they're not following the guidelines as required. So it will be an interesting one to watch. We could talk for quite some time on kind of some of the additional points around this. Just a few more, I think it would be worth flagging. Our current thinking is that employer liability policies should respond to a civil claim if it were to arise. As I said, that would be a difficult claim to bring for an employee. They would have to first show that they got the injury in the workplace and that there was then a duty failing. But generally speaking, we would say that most EL policies would, from our review, respond to those types of claims. That is different to business interruption or property damage, which we think is going to be a very difficult claim to bring for COVID-like losses. Track the government guidance, document the government guidance. If you have over 50 employees, you have to actually post what your management plan is on your website. And lastly, that is the bare minimum. I think this all goes back down to confidence and worker engagement of it's a journey. You've got to bring them with you. There will be a lot of very nervous people out there. From the discussions we're having, this is probably as polarizing as Brexit. There are very robust people in the kind of the community who don't see this as a problem, and there are others, for their own very personal reasons, who will be very nervous. So it's going to be very much a strong communication engagement program to get everyone comfortable about returning to work where we think that they have to. Tim, that was all I was going to say in that slot, but I'll be happy to take more detailed questions.
Yeah, no, that's very helpful, Doug. Thank you. We'll move on to questions that have come through on the room facility. Just a couple of these talk about, I think, going back to the point I was making on people refusing to come back to work and this section 44, section 100 reasonable belief. As I said, there really are so few cases on this. You don't really see many cases. There's not a lot of authority. But the point I made around people feeling safe is in the workplace. There's an argument it could extend to public transport. And obviously that is hard because that's completely out of your control as an organization, unless there's a facility for alternative ways of getting into work. That's cycling or driving or walking, but for a lot of people, public transport is going to be a key thing. And again, on the basis of a reasonable belief that there may be a challenge there. I guess again, it's having discussions with the employees, trying to understand where their concerns are. If there's a particular concern about the sheer number of bodies on trains, whether there's staggered work time starts, as Doug's guidance talks about as well, the idea of missing out on what is sort of rush hours and having people coming into work at different times. But yeah, it's not easy, and it's certainly not easy where it's outside of your control as an issue. So that's certainly there. And there's another question as well about just going back to this childcare point. So regardless of going back or kids at home, actually once you get to the summer holidays, you will have a situation where kids are going to be at home, and query whether there'll be the ability to put childcare like you might normally have done, whether with relations or whether in nurseries and things like that, if those aren't open. I think the same principle applies in that your employees don't have any particular protection. I mean, there's clearly a problem, there's clearly an issue there. On the legal face of it, it's an issue that the employee needs to sort out and solve themselves, because they're the ones with the contract to be coming to work for you. But obviously on the human side, it's a pretty terrible situation for all in, and it's about accommodating. And I guess that may be where, if furlough is obviously still going to be running through the summer, you may have employees who go onto furlough in that time as a form of compromise, on the basis that furlough for childcare is an express ground to allow you to do that.
Doug, there's an interesting question here for you, which is sort of the reverse of what we've been talking about. So not so much bringing people back to the workplace, but what about those employers who have found that home working is quite effective, or office-based staff who are going to have to work from home probably for the foreseeable future? What's the employer's health and safety obligation there? Should they be conducting workplace assessments, providing equipment? Do you think there'll be any sort of further guidance on this?
Yeah, that's a very topical, as of really this morning. This was being kind of ventilated by a number of quite senior people in government and elsewhere. Really interesting. So short answer is, to date, kind of the perceived wisdom is that where people are home working, this is in a temporary basis. And as such, you don't have to undertake a full risk assessment, and that will curtail the amount of equipment that you need to provide. As soon as you move into a situation where it's more permanent, and I think that's what we're looking at now. I think that's the right way of looking at this. Where people are going to be working for another 4 to 6 months, that's a permanent home working arrangement. And I think some form of risk assessment needs to be undertaken and documented in the ordinary course. And I think a part of that, I think there will be requests for equipment to kind of manage the risks. So this morning, a very senior HSE health and safety executive, director, raised this exact point, saying that staff need to be protected in the home workplace, and also their mental well-being needs to be considered. So I think we will be shifting into where us office dwellers are now all working from home. Certain steps will have to be taken to make sure that their health and safety is protected. I, for one, have a dead leg because my seat is so uncomfortable. So I think everyone is probably not set up quite as well as they should be.
Yeah. Okay. Thanks, Doug. A couple of quick questions came in on furlough. One question around whether, when you're thinking about who would be put onto furlough, who would be staying back, whether you'd have a written policy in relation to your principles, or just have something that you keep on file as a document to point to. I think a policy would probably be beyond what a lot of people are doing. I think that the right the right thing will be knowing yourself and having clear and having it part of your discussions with employees around who you bring back, who stays, clarity and transparency around what your what your principles are, and exactly as you say in the question, making sure you keep that on file just in case you're ever challenged later as to why certain decisions were taken. You've got a written record of it. So I think that would be very sensible. And there's another question on furlough as well, which is around the point I made around if you end furlough, let's say before the end of the government furlough period, making sure you don't break a 2-week period. The point I was making was that if you're rotating employees on furlough, say you have on for 3 weeks and then off for a week or two and then back on furlough for 3 weeks, for those guys, don't cut that short, the sort of the 3-week block. If actually you've had someone who's on a long period of furlough, they haven't come back, then obviously that's just multiple weeks of furlough. So you don't sort of regard them in 3-week chunks. It's just, well, then they've just got it's a 3-week minimum. So someone could be on for 5, 6, 8, 9 weeks. So it doesn't matter then if you're ending it. So sorry if there was any confusion there.
Another question here around, sorry, Tim, consultation around bringing people back to work. I said it would be a good idea to engage with employees and consult with them about your approach on selection. Someone who's asked, should that be a formal consultation exercise or would something more informal be okay? And I think something informal would be absolutely fine here. You know, this is not a formal collective consultation on redundancies. It's not a formal collective consultation on changes to terms and conditions. What you're really trying to do, as I said, is to get employees on board with your approach and also to flush out issues. So, and however you want to do that, I think would be absolutely fine. You know, an online survey would be absolutely appropriate in these types of circumstances.
Adam, one point I would kind of add to on that is it is important to document this and have a clear paper trail. So just in case anything did go wrong, that given that there's this quite eye-catching requirement under the health and safety element to kind of engage with workers and trade unions, I think it could be done in however you see fit, but it should be documented.
Absolutely, certainly on the health and safety risk assessment side of things. I mean, there's another question here around, well, how likely are claims going to be, and how likely are people going to succeed if they're complaining about either being put on furlough or being brought back on furlough? As you said, people have very different views about this. Some prefer to stay at home, some will want to get back to work as soon as possible. Again, I think documentation is going to be important. So Tim mentioned having sort of a rationale document about why you've put people on furlough and what your general approach has been. But the real risk area, I think, comes in relation to discrimination. So as long as you can justify your decision on an objective basis and you've got a paper trail which backs that up, you would have a good chance of defending any claims, I would have thought.
Yep, great. I'm conscious we've hit our past our Q2 deadline, and apologies again for starting a little bit late, but I think we'll draw it to a close there. Thank you very much for everybody who joined us this afternoon, especially thank you for those who have posed questions as well. We hope you found this session helpful, and just to say there's another midweek briefing next Wednesday through our webinar program, which is looking at issues around restructuring, collective consultations, redundancies, things like that. So you'd be more than welcome to join us again then. So thank you very much and enjoy the rest of your afternoon.